come to order. Messages from the Senate.
Message from the Senate. Mr. Speaker, I hereby announce the passage by the Senate of the following Senate files herewith transmitted. Senate Files 321, 380, 745, 887. Signed, Joanne M. Zoff, Secretary of the Senate. Mr. Speaker, I hereby announce the passage by the Senate of the following Senate file herewith transmitted. Senate File 1060. Signed, Joanne M. Zoff.
First reading of Senate files.
Introduction and first reading of Senate File 321, an act relating to health. The bill is being referred to the Committee on Health and Human Services Finance. Introduction and first reading of Senate File 380, an act relating to workforce development. Albright moves that Senate File 380, House File 758, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered.
Introduction and first reading of Senate File 745, an act relating to state government. Isaacson moves that Senate File 745 and House File 695, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered.
Introduction and first reading of Senate File 887, an act relating to health. Lane moves that Senate File 887 and House File 662, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered.
Introduction and first reading of Senate File 1016, an act relating to nursing. Fritz moves that Senate File 1016 and House File 1124, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered. Calendar for the day. The first bill on the calendar for the day is House File 1160. The clerk will report the bill.
House File 1160, number 2 on the calendar for the day, an act relating to Judiciary.
The author of the bill, Representative Hilstrom.
Thank you, Mr. Speaker and members. Members, this is the Judiciary Finance Omnibus Bill. Members, this proposal is very similar to the Governor's budget request. As you know, when the Supreme Court submitted their budget request to the Governor's office, they requested $34 million over their current spending. The Governor then added the items that are not within the Supreme Court's jurisdiction, including the public defenders and other areas, making the budget request that came to our committee $44 million over the base. Members, our budget target was $30 million over the base from the general fund, and what we chose to do in this bill is fund the Governor's recommendation, but instead of giving the judges the pay increase of 4 and 4% as they requested, their pensions is actually being carried in the pensions bill and not in this bill. Therefore, the pay increase for judges here is 3% and 3%, as well as for staff. This also includes a 1% increase to the Tax Court, the Board on Judicial Standards, and Sentencing Guidelines Commission. We put additional funding in this bill to fund the Public Defender's Office, as the attorney registration fee that currently the Supreme Court has added to attorneys' licenses will be expiring. And that funds 25 public defenders. So we have added the $1.9 million in 2014 and $1.9 million in 2015 to make certain that those 25 public defenders won't be laid off. There's additional specialty court funding in the bill, $925,000 in 2014 and $925,000 in 2015. Members, we know that specialty courts are very effective in keeping folks from recidivating. We know that we have great success with our drug courts, with our new veterans courts, with other DWI courts, and we want to make certain that the courts have the ability to expand that. Some of the areas that we are missing specialty courts is in greater Minnesota, and we want to make sure that all people have the ability to access these very effective courts. The other piece that's in this bill is Representative Moline has a provision that the Court of Appeals judges who are from greater Minnesota, who live outside 50 miles outside the metro area where they're chambered here, would be entitled to housing reimbursement and mileage, much like we in the legislature are. Members, the Court of Appeals are made up of judges, and at least one judge has to be from every single district. And so we want to make certain that those judges are able to do their job as they are here in St. Paul. The way that we pay for these provisions is we have done some modifications. We know that conciliation court is the amount of time that it takes to do many of the cases in conciliation court really varies on the amount of money that people are fighting over. So we have made a graduated fee for conciliation court fees. So if what you're fighting over is under $5,000, that conciliation court filing fee will be $110. If you're fighting between $5,000 and $10,000 is the amount, it will be $125 for the filing fee. And if you're fighting over $10,000 to $15,000 in conciliation court, your filing fee would be $150. Members, that increase going up from $10,000 to $15,000 being allowed to be in conciliation court, that is in current law and that will be implemented in the next biennium. We increase the criminal traffic surcharge by $15. And then we do a bond reinstatement fee. Basically, when defendants get sent to jail and then they want to bond out, in many instances, a bond company will put a bond for the defendant, and then if the defendant fails to appear, the bond company makes a motion before the court to get their money back once that defendant has been rearrested. This says that if the bond company is going to come and ask for that money back, they need to it's like paying a filing fee like we require everyone else to do. They're going to have to pay the state a portion of that fee. And the last thing that we do in this bill that relates to funding is the court technology fee. The court has been implementing e-discovery and e-filing, requiring everyone to submit through technological means. And it's currently implemented in 7 counties, but it will be implemented in 87 counties across the state. Not all counties have the technology capability in order to implement that system or deal with that system as it's being implemented. And so we put a $2 filing fee that will generate revenue for things like our local probation, who needs to then file their pre-sentence investigations with the court via technology. That also will make the funding available for public defenders who will also need to do it. So members, that is the technology fee. The last thing that's in this bill is an expanded background check for guardians and conservators. Members, we have found in Minnesota that there was one particular guardian who was charged with taking care of vulnerable adults. And what we found out after she committed very many acts of stealing money from her vulnerable clients, we found out that many years before she had lost her attorney's license. She lost her attorney's license because she was neglecting client files. And what we found is that no one is doing a background check on whether or not people had a professional license that was suspended or taken. And so this would say it's going to broaden the scope of the background checks that are currently done and just make them more frequently. Currently it's done every 5 years. This would make them done every 2 years instead. And members, that's the bill, and I'll stand for questions.
There is an amendment at the desk. The clerk will report the amendment.
Scott moving to amend House File 1160, the second engrossment as follows. The amendment is coded A10.
Representative Scott.
Thank you, Mr. Speaker. This amendment, which is the A10 amendment, would eliminate the Court of Appeals judges' mileage and lodging reimbursement for judges residing more than 50 miles outside of St. Paul. I would ask for your support, members, on this. It spends too much money, increases fees, and sets a dangerous precedent by giving public employees additional compensation based on where they choose to live. And so, members, I would encourage a green vote on this amendment. Thank you.
Representative Moline.
Thank you, Mr. Speaker and members, and Representative Scott. Members, I would ask you to vote no on the A10 amendment. This provision in the bill that Representative Scott is taking out simply treats judges in Greater Minnesota who serve on the Minnesota Court of Appeals same as legislators are treated. The Minnesota Court of Appeals is only made up of 19 judges, and it is required that there be one judge from each congressional district. Right now, out of the 19 judges, there are only 5 that reside outside of the metro area: Duluth, Moorhead, Owatonna, St. Cloud, and Walker. And although those judges live outside the metro area and are required to serve in the Court of Appeals, being from the 1st, 7th, and 8th congressional districts, they have to pay out of pocket for their living expenses near their chambers in St. Paul. So this is simply bringing fairness to the Court of Appeals and making sure that Greater Minnesota has the same opportunity to be represented in our third branch of government as does the metro area. So members, I would ask you to vote no on the A10 amendment.
Representative Scott.
Thank you, Mr. Speaker. I'd like to request a roll call first before I make some
Roll
more.
call being requested. Seeing 15 hands, there will be a roll call.
Thank you, Mr. Speaker. If Representative Moline would yield to a question, please.
She will yield. Representative Scott.
Thank you, Mr. Speaker. Representative Moline, who brought this bill idea to you?
Representative Moline.
Thank you, Mr. Speaker and Representative Scott. Actually, the judges from Greater Minnesota who serve on the Minnesota Court of Appeals brought this bill to me 2 years ago. I first introduced it 2 years ago, and they're having to pay a lot out of pocket. They leave their families behind all week long, just as legislators do from Greater Minnesota. They leave their families and homes in Greater Minnesota and come down to St. Paul to work for their week and be near their chambers. And the fiscal cost on the bill is $46,000 for the first year and then $115,000 thereafter. So it's pretty insignificant overall, but to them it makes a great deal of difference.
Representative Scott.
Thank you, Mr. Speaker. Well, members, be careful how you vote on this bill. This is going to set a huge precedent for anyone else that lives or that works for the state of Minnesota that has to commute to the cities or come to the cities for a period of time with their jobs. It would open the door to any official with statewide jurisdiction. So the Public Utilities Commissioners, for instance, perhaps they're going to start asking for lodging and mileage as well. Again, I think this sets bad precedent, folks. They are not citizen legislators. This is what these people do for full-time employment. They know that when they apply for the job. This isn't something that most of them are elected to do. They all initially apply for this job knowing ahead of time that they're going to have to pay mileage and housing. So again, I would just encourage a green vote on this amendment. Thank you.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 57 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There is another amendment at the desk. The clerk will report the amendment.
O'Neill moving to amend House File 1160 to second engrossment as follows. The amendment is coded A11.
Representative O'Neill.
Thank you, Speaker. Members, this amendment returns the language back to a standalone bill that our wonderful chair had. It was House File 1398, and it has to do with the court technology fee. Now, when the courts came, and they didn't ask for additional money to implement all the changes in the technology, but we do have a bill here in front of us that does provide some funding for that. And this bill would give them a little bit more leeway because as the appropriations bill was put together, it added additional mandates onto the court, and this would remove some of those mandates. With this amendment, they would no longer have to create a board, and they would not have to basically essentially create a grant-making process to distribute the funds. So I would encourage a green vote on this, and I would like a roll call, please.
A roll call being requested, seeing 15 hands. There will be a roll call. Representative Hilstrom.
Thank you, Mr. Speaker and members. Representative O'Neill, thank you for recognizing that the technology fund is an important piece, and I really appreciate that. Members, what this does is make the technology fund just for 2 years. However, Representative O'Neill, I wanted to point out that on line 2.3, you actually require a report ongoing every year, even though the money is only for 2 years. And so, members, I would ask that you vote no on this amendment. what we have learned that just the public defenders alone this biennium will have $2.5 million in cost to implement based on e-discovery and e-filing requirements in this biennium. Their cost ongoing is more than $7 million. And so one of the things that we need to make sure that we do is if we allow the mandate that people file in our courts electronically, we need to make sure that the users of the court actually have the ability to comply with that. And that's what the language in the bill does.
Representative O'Neill.
Thank you, Speaker. Thank you, Chair Hilstrom. I wanted to clarify that. I appreciate you bringing that to my attention. And as an accountant, I sometimes look into the future because we do realize that we'll be collecting some funds. And the court didn't ask us for a specific amount, and yet we're raising revenue. And so there's a very good potential, Chair Hilstrom, that we'll be having extra after the 2 years is done, which we would then want to report after the fact. And so that's why it's continuation past the 2 years where we're collecting. We still will be spending potentially past that 2 years. So I really do appreciate that question. That is why it is still in that amendment. And I would just really encourage a green vote because this does give more freedom to the court. It does not, it removes the mandate from them having to set up a board. It removes the mandate from them basically to set up an entire granting process to distribute the funds. I think that we can trust our courts to be able to distribute as they see fit. And it is in addition to what they did come and ask us for. So I would encourage a green vote. Thank you.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 57 ayes and 71 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendments.
Drazkowski moving to amend House File 1160 to second engrossment as follows. The amendment is coded A12.
Representative Drazkowski.
Thank you, Mr. Speaker. Mr. Speaker, there is a technical change on this particular amendment. I was notified today from House Nonpartisan Fiscal Staff that in the amendment where it inserts the number 135, it should be 135.31. So if we could add 0.31 after there. The spreadsheet that was being used rounded up, and so it wasn't included to that level.
The clerk will report the modification.
Drazkowski is modifying his amendment on on line 1.3, delete 135 and insert $135 and insert $135.31.
Representative Drazkowski, to your amendment.
Thank you, Mr. Speaker. Mr. Speaker, members, this amendment merely gets rid of the tiered approach to the conciliation court fees and puts it back to a basic fee. It keeps the amount the same as it is in Representative Hilstrom's bill, but puts it to one single fee so it's easier for the courts to administer and easier for people to arrive at what their fee is when they go into access our conciliation courts. I do have an amendment too, Mr. Speaker.
Right, there is an amendment to the amendment. The clerk will report the amendment.
Drazkowski moving to amend his amendment to House File 1160 as follows. The amendment is coded A14.
Representative Drazkowski.
Thank you, Mr. Speaker. Mr. Speaker, members, this amendment to the amendment actually reinstitutes, takes that flat fee then back to the $65 amount that it is currently in law, which would decrease the amount that is in the bill from 135 down, or actually from the tiered amount down to 65 where it is currently in law. What it would do, though, is it would reinstate the use of the $75 attorney fee that is used to pay for public defender services. And members, this, as far as I know, is the only fee so far that this legislature has contemplated reducing or eliminated. And so in this particular budget bill, it does eliminate the $75 fee that attorneys pay that has been in place for 4 years. And this would put the fee where the most interest is, members. The interest for attorneys is that they can have an active and capable public defender system that not only does a good job of representing the defendants, but also helps expedite and move the system along in a way that doesn't chew up the plaintiff attorney's time as well. So this is a good amendment. I'd encourage your support, and Mr. Speaker, to ask for a roll call.
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Hilstrom.
Thank you, Mr. Speaker and members. Members, we need to be really careful on this piece. Currently, the Supreme Court is the one who has charged lawyers the $75 fee. The Supreme Court has the sole jurisdiction over attorneys. The legislature does not on the requirements for being a lawyer. And so in 2009, I actually carried a bill to require this $75 be put on to pay for the public defenders, and learned back then that the legislature doesn't have the authority to do that. The court, however, does, and in 2009, they did do it. They chose to impose this $75 fee on lawyers. However, during the court's decision, it specifically said that they were doing it because the legislature failed to do their job. Providing for public defenders is a constitutional requirement for the state of Minnesota, and this legislature has a responsibility under the Constitution to do that. And so what would happen is, if you adopt this amendment, is this directs the Supreme Court to charge a $75 fee, which we don't have authority to do. We can ask them to do it. However, if they don't, what will happen is 25 lawyers in the public defender's office will be let go. There isn't funding for them. So, members, I would ask that you not adopt this fee, and if the Supreme Court so chooses to do a $75 fee, in addition to that, that would be something that they would be able to do, but we don't have the authority to make them do that, and it would put a 25-lawyer hole in the public defender's office.
Seeing no further discussion on the amendment to the amendment, the clerk will take the roll. The clerk will close the roll. There being 59 ayes and 69 nays, the amendment is not motion does not prevail. The amendment is not adopted. To the underlying amendment, Representative Hilstrom.
Thank you, Mr. Speaker and members. Members, I think that it is fair to have a graduated conciliation court fee. We know that it takes more work for the court to deal with cases that are between $10,000 and $15,000 than a case that is under $5,000. And to go from $65, which is the current filing fee, to $135.31, I think is the number. I think that that is a pretty big jump, and I would ask that you leave the graduated fee in place.
Representative Abler.
Thank you, Mr. Speaker and members. And I don't usually speak a lot on judiciary bills, but I have two observations that might be useful to the body. Just one in general, a 19-page omnibus. I mean, Mr. Speaker, this is, can't you do better? Give their committee some money so they can have a decent-sized omnibus. 19 pages. Sorry, they do need the fees, obviously. The second observation is that I think of all the, Chair Lincheski is gone, my classmate, but I think of all the fees and taxes you've proposed this year, the lawyer one you just turned down would have been the most popular one in a survey. And so I'm sorry we missed the opportunity to make our people happy. So maybe next year, Mr. Speaker, and I hope that was helpful. Thank you.
Representative Jaskowski.
Thank you, Mr. Speaker. Mr. Speaker, I'd withdraw the amendment at this time.
Representative Drazkowski withdraws his amendment. There is another amendment at the desk. The clerk will report the amendment.
Drazkowski moving to amend House File 1160, the second engrossment as follows. The amendment is coded A13.
Representative Drazkowski.
Thank you, Mr. Speaker. Members, this amendment takes the funding that is provided in the bill for the public defenders and the guardian ad litems and replaces it with contractual arrangement for the guardian ad litem and public defender services. It replaces it at a rate of $70,000 per year for the salary, which I understand is the average salary of the public defenders. It encourages volunteering for the guardian ad litems, as a good number of them do now, and however this bill is headed to the contrary. It's headed in the direction of making the guardian ad litems full-time employees and adding more liability to taxpayers of Minnesota. And members, this amendment illustrates if we could bring about some reform to this area. This illustrates what reform could do. It would save the state, the taxpayers of Minnesota, $94 million. $94 million that we wouldn't have to raise in alcohol taxes. We wouldn't have to raise cigarette taxes. We wouldn't have to raise all the fees we're raising in this bill. Members, I'd encourage you to support the amendment. Mr. Speaker, to ask for a roll call.
Roll call being requested. Seeing 15 hands, there will be a roll call. Representative Hilstrom.
Thank you, Mr. Speaker and members. Members, what this bill does is it takes the guardian ad litems, those are the folks who represent abused and neglected children, and make a recommendation to the court about what is in their best interest, and says you're not going to be employees anymore, you're going to be volunteers. And the second piece that it does is it takes the public defenders and it makes them contract employees instead of state employees. And members, not only does it do that, but it also makes the Hennepin County public defenders contract employees as well, and those aren't just straight up state employees, those are shared expense. And so members, I would ask you to vote no.
Representative Scott.
Thank you, Mr. Speaker. Well, you know, I think this is an area of reform that we could really make. Years ago, I spent some time working in the county attorney's office in Lincoln County, Nebraska, which is western Nebraska and North Platte, and this is exactly what they did with public defenders. They were contract employees. They were able then to have a practice as well on the side, but they were contract employees. You know, this is one of the things that maybe we need to be looking at in the future, is having more people be contract employees, which allows them to work for the public sector and for the private sector. It allows them more opportunities, and it still meets the needs of the state. So I would encourage a green vote on this amendment. Thank you.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 55 ayes and 73 nays, the motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment.
Pugh moving to amend House File 1160, the second engrossment as follows. The amendment is coded A8.
Representative Pugh.
Thank you, Mr. Speaker. Members, the A8 amendment eliminates the House budget base adjustments to the Judicial Standards Board, the Sentencing Guidelines Commission, and the Tax Court. It is concerning to me that this budget reflects spending increases in these three areas. We're giving state agencies budget, base budget increases that they didn't request, that weren't in the governor's budget, and that they don't need. I recognize that the amounts are small. In the first biennium, we're talking $15,000. And in the next biennium, we're talking just $29,000. but a few $1,000s here and maybe a few $10,000 there. You know, pretty soon we're talking real money and real cuts. In fact, members, our constituents are calling upon us. I know that mine are. I've heard from them, and I think their request is reasonable. What I've been hearing is that we go line by line to justify our spending, to justify the existing spending before spending more of our constituents' hard-earned money. And so what are we doing? We're adding a line here and we're adding a 1% increase. So, you know, it's concerning to me, and, you know, I have to ask myself, you know, who's going to pay for this? And it's really crystal clear to me who's going to pay for this. It's our hard-working constituents. In fact, I have a report here that I'm very familiar with. It's from the Minnesota Department of Revenue dated January 7th of this year. And it details all 87 counties, and it details how many tax filers are in each of those counties, and how many of those filers are projected to fall into that fourth and potentially fifth tier. And if all of those constituents remain in Minnesota, Carver County, one of the counties I represent, will be number 1 bearing this burden. And Hennepin County is number 2, so I'm very sensitive to any excessive spending that we don't need to be doing. So, yes. So, you know, it might sound petty to be calling out for a $44,000 reduction, but I feel it's incumbent upon myself. You know, we have to start somewhere, and I would invite you to join me in voting green. If I could request a roll call, please.
Representative Pugh requests a roll call. Seeing 15 hands, there will be a roll call.
Thank you. So I invite you to join me and start somewhere, and let's start paring back and living within our means. Thank you.
The member from Hennepin, Representative Hilstrom.
Thank you, Mr. Speaker and members. Members, this is a 1% over the governor's recommendation. However, the governor didn't recommend giving these agencies everything that they asked for. And so this does take care of some of their added employee cost and insurance costs. It's not as much as they had requested. It is a little more than what made it in the governor's budget, but only by 1%, and I ask that you vote no.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 69 nays, the amendment is not adopted. There are no further amendments at the desk, are there? Okay. There is one more amendment at the desk. The clerk will report the amendment.
Johnson B. moving to amend House File 1160, the second engrossment as follows. The amendment is coded A9.
The member from Isanti, Representative Johnson.
Mr. Speaker, this amendment deals with the surcharges on mostly on citations that law enforcement officers give to the people of Minnesota. In the past 27 years, I've seen these fees increase dramatically. And this has caused a backlog in the court systems, log jamming our courts. People are going to court instead of simply paying the fine to see if the officer shows up to court. And as soon as the officer gets there, they plead guilty and go pay the fine. Also, more and more jurisdictions are now using what's called administrative citations. It completely bypasses the court system. They're given a ticket. Instead of paying the $180 speeding ticket, they pay a $40 ticket that's divided up between the jurisdiction and the prosecuting attorney's office. The courts get nothing from this. These fees are getting so high that the public is creating increased costs for the counties with the overtime. Because when the person decides to go to court, it causes the officers mandated to go as well, causing overtime for these departments and increased costs. By raising these fees on these and surcharges on the citations, it's going to increase costs not only to the counties and the cities, but also to the state, because our state troopers that we have are not able to write administrative tickets. They have to write the regular tickets. They're the ones that are spending a lot of time in court. I've sat 5 hours in a courtroom waiting to hear a speeding ticket. That's a lot of overtime that gets paid out. Representative Hilstrom did a great job in coming up with creative ideas to raise the funds. The problem is, I don't believe that on this situation, the funds she's going to raise on these fees are going to materialize, and we're going to end up with a hole in the budget. These changes that I've made on this amendment still keep the budgets at or near the governor's recommendations for these funds without increasing them that dramatically. I do hope you will vote green on this. Thank you.
Member from Hennepin, Representative Hilstrom.
Thank you, Madam Speaker and members. Members, the A9 amendment actually eliminates all the fees in the bill. It eliminates the court technology fee, the criminal traffic surcharge, the conciliation court graduated fee, the bond forfeiture funding, and the way that it then takes care of that loss of revenue is that it takes the pay increases to the courts down to 1%. It removes the 1% compensation that is in the bill that we just defeated in the previous amendment. Members, I just ask you to vote no.
Representative Johnson.
Madam Speaker, I do request a roll call on this.
Representative Johnson requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Seeing no further discussion to the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. There being 55 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 1160.
Third reading. The member from Wabasha, Representative Drazkowski.
Thank you, Madam Speaker. Members, I encourage you to vote no on this bill. This is a bill, again, that continues to increase the amount of money that Minnesotans are required to pay. It includes more spending that's not needed, that's wasteful spending, and I would encourage you to vote no on this particular bill. Members, I would like to recognize the work of Representative Hilstrom. She's been a great colleague to work with on this committee. We've had bipartisan discussions, and they've been very good, but the bill lacks any bipartisan material. And I'll tell you, We were hoping, at least those of us who were in the minority on the committee, that we'd be able to have some bipartisan components to this bill. We offered some of the amendments that we offered in committee here today that would have demonstrated that would have brought some fiscal responsibility back to the bill. But members, this bill doesn't have the fiscal responsibility, doesn't even come close. It continues on the same track that we've been on with the last two budget bills that we've entertained here on the House floor. Members, this increases spending by $46 million, a full 6.3% increase over current spending in these areas. It includes increases in salaries for judges throughout the state of 6% over the biennium. So members, for our district court judges in each of our areas, their salaries are $129,000 a year. So this bill will give them a $7,740 raise, bringing their salary to $136,740 a year. The Court of Appeals judges, all 19 of them, make $137,552 a year. This increases their salary by $8,253, so their salary will be $145,805 per year. The Supreme Court, their salary will go up to $154,740 a year. Members, you heard some of the fees that we tried to remove from the bill. They are numerous, especially the most offensive ones, I think, to the people of Minnesota are those that are going to be filing in conciliation court for a renter who is maybe just starting out in their adult life, owns a duplex or a triplex and has to take their a landlord, who has to take their renter to small claims court to collect a couple months' rent. Their fees will go up dramatically. As you can see in here, it's a total of $4 million a year increase in fees for conciliation court. The court technology fee, we could have avoided actually writing that into law. We attempted to put that into session law, which made sense. It would have provided an evaluation period, which when the next legislature comes back here in 2 years during their budget time, they would have been able to take another look at that, evaluate where we are. The courts have actually said that 12 to 18 months, their technology program will be implemented. It will be done. And we know that the technology thing is important, but we found other places in the bill that could have paid for it. We could have set some priorities. This bill does not set priorities. It increases funding significantly in every area of the bill. And members, when everything is attempted to be a priority, there are no priorities, and that's reflected clearly in the bill. The growth in the bureaucracy, the growth in state government is very clear in this bill. Not only do we have, as I mentioned, the fees that are in numerous areas, a total of $23 million in additional fees for people who want to access our courts, people many times who are not of means, who instead are going to have to pay these fees for a large extent because we are letting the lawyers in Minnesota get rid of their $75 fee. Members, we are trading special interest group. The lawyers' lobby is getting rid of their $75 fee, and in place of that, we are charging many of the poor people in Minnesota that need to access our courts a total of $23 million a year. In addition, we've got another 35 FTEs in this bill. As the other two bills have gone, we continue to grow government. We continue to grow the bureaucracy. Members, taxpayers are going to pay more because of this bill. It's got wasteful spending in it. You heard Representative Pugh. They're spending in this bill that the agencies did not even ask for. But they've got additional spending in the bill. Wasteful spending in the special interest for lawyers that's included in this bill. More than reason enough to give it a solid red vote. Appreciate it, members. Thank you, Madam Speaker.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker. I just want to echo the comments of Representative Drazkowski about this bill. There are a number of provisions in here that I see as very wasteful, not the least of which is the one that I had the amendment for, allowing the appeals court judges' salaries, well, basically their salaries would be now out of line because the ones that are outstate would come to the metro area and they would get some living expenses in there and their mileage expenses covered, which puts them out of proportion with the rest of the judges in the state. And secondly, you know, once again, as Representative Drazkowski said, that wasn't even a provision that was asked for by the courts. We have several provisions that are like that, and you know, it's one thing to give an agency what they request. It's another thing to give them additional funds when they weren't even requested. Folks, I don't know what seems to be going on around here, but the left side of the aisle seems to think that we are awash in money, that we are awash in more taxpayer funds, and I'm not seeing it. I'm not seeing it, folks. And by the time I think you folks are all said and done, you're going to raise $3 billion in taxes and fees. And this bill is a prime example of those fees going up. And one of the things we heard in Judiciary was this access to justice problem. And by increasing those fees to the conciliation court, how is that giving more people access to justice? Folks, this is wasteful spending. A lot of it's very unnecessary. There are some decent parts of this bill, some things that needed to be funded, but it's very unbalanced and it has no bipartisan support. And I also wanted to just say that Representative Hilstrom did do a good job in reaching out to us and discussing these things with us, but discussing the issues is one thing. The other thing is, you know, it's quite a different thing not to take any of our amendments, not to take any of our suggestions. We might as well have not been in the room during the time that we were having these hearings. So, folks, I would just encourage a no vote on this bill and hope that we can do better next time. Thank you.
The member from St. Louis, Representative Moline.
Thank you, Madam Speaker and members. I would encourage a green vote on this bill. I want to thank Representative Hilstrom for the work that she did in a committee. I think we did have a very good and bipartisan committee, and there was a lot of really good discussion going into putting this bill together. So I want to thank Representative Hilstrom for the work that she's done on this bill. And Representative Drazkowski, you know, our judiciary isn't a bureaucracy. It's the third branch of government. And it is really important that we adequately fund them so that Minnesotans do have access to justice, and so that Minnesotans who are accused of a crime are able to have adequate time with their public defender. And Representative Hilstrom's bill reflects those values that we have in recognizing the importance of our third branch of government. So I would ask for a green vote. Thank you.
The member from Hennepin, Representative Hilstrom.
Thank you, Madam Speaker and members. Members, I'd like to thank all the members of the committee. We really did have really great discussions in a bipartisan fashion. I'd also like to thank the committee staff and nonpartisan staff for all the work that they put in to helping put together this bill. And members, I really want to make it clear that the third branch of government is really important. And we did not have the ability to give the judges all of the pay increase that they asked for. They asked for 4 and 4, and we gave them 3 and 3. The pensions are going to be carried in another bill. We don't have that in our area. So the idea that we gave everybody everything they wanted and more is just not so. Members, we did put additional funding into the public defenders because that attorney registration fee is expiring and we don't have the authority to put it back on. The court does. In addition, we know that specialty courts are very effective. We've been working very hard in Minnesota, especially as our military men and women come back. We now are implementing specialty veterans courts in this state. And now we have additional resources to actually do that statewide. Members, I ask for your support and ask for a green vote.
There being no further discussion to the bill, the clerk will take the roll. The clerk will close the roll. There being 71 ayes and 59 nays, the bill is passed as amended and its title agreed to.
Madam Speaker,
Representative Doubt, for what purpose do you rise?
privilege of the House.
Please state your privilege of the House.
Thank you, Madam Speaker. I rise to speak a little bit about what happened today in the Ways and Means Committee and a little more about what's been happening all session. You know, House File 1765, we actually had a discussion about on the House floor earlier this week, on Wednesday, when the committee report from the Rules and Legislative Administration Committee came before the House. And we also discussed in Rules on Tuesday when we were asked to basically waive the House rules to allow this bill to advance. And we find concerning in the minority the way that not only we're being treated, but the way that the people of Minnesota are being treated and a way that this institution is being treated. We expected Democrats after the last election to take billions of dollars from the hardworking taxpayers of Minnesota. $2.6 billion in tax increases already proposed in this body, and hundreds of millions of dollars in fees and surcharges. We expected Democrats to make government more inefficient and ineffective, hundreds of new government workers, new government offices with duplicative functions. We expected Democrats to pass regulations that will smother our healthy economy, mortgage regulations, our health insurance exchange, and we expected Democrats to pay back special interests, to unionize privately owned businesses. I'm talking about the child care unionization. We expected them to give extra unemployment benefits to some Minnesotans, but not to all. We expected Democrats to put the wants of adults ahead of the needs of students. And we expected Democrats to raise the cost of public projects.
A privilege of the House is confined to the issues of the functioning of the House, and you were getting to that with your comments about the functioning of the Ways and Means Committee.
Yes,
the substantive debate is outside of the bounds of a privilege of the House, so if you want to stick to the issue of the Ways and Means Committee, that would be within the realm of the privilege of the House.
Certainly. Thank
Representative
you.
Doubt.
Thank you, Madam Speaker. I actually only had one more thing that we expected from Democrats, so I might as well just finish that quickly before somebody else interrupts me. And we expected Democrats to step on the negotiation rights of management and workers in favor of high-paid union bosses. What we did not expect is what happened in Ways and Means today and what has happened continually to not only the minority in this body, but to the citizens of Minnesota. What we did not expect is to go around House rules when it's convenient simply because you can. We did not expect Democrats to fail to give the public proper notice for committee hearings. We did not expect Democrats to fail to allow for public input prior to amendment deadlines on omnibus bills. And we did not expect Democrats to cut off public testimony and members' questions when there was more to be heard and to be asked. We did not expect Democrats to radically change bills with provisions such as House File 1765 that was added today in Ways and Means. Okay? Ways and Means isn't a place where we discuss policy bills. Okay? This is a bill that we actually waived the rules so that this could proceed. When we asked Representative Nelson, who's carrying this bill, why we needed to waive the rules, his response was, this was brought to me by people above my pay grade. When we asked him what that meant, he said the Speaker of the House asked him to carry this bill. I spoke up the next day on this floor when we took up that committee report. And after making my point that the rules of this House should apply to every member of this body, I kindly withdrew my objection and I allowed the bill to proceed. But how did Democrats respond to that? They stuck it in a bill today in Ways and Means. When it's scheduled to have the hearing that we're allowing it to have by waiving the rules next week. In fact, the chair of the Commerce Committee, Representative Adkins, stood up himself in Ways and Means, not stood up, but spoke in Ways and Means himself and said that this was scheduled for a hearing next week. The bill is proceeding on its own. Bipartisan opposition today in Ways and Means when people said we don't allow policy bills to be added as amendments in Ways and Means. Representative Detmer withdrew one yesterday when Democrats objected. So the rules of this body have to apply to the minority, but they don't have to apply to the majority, and apparently they don't have to apply to the Speaker of the House. Are we going to treat the people of Minnesota this way? Not giving them proper notice? Not giving them an opportunity to come to committee and talk about bills that are going to be introduced? To talk about amendments that are going to be introduced? Walk out in the hallway. There's lobbyists that have been here certainly far longer than me, but much far longer than all of you as well, that have no clue on what's going on because the Democrats don't feel like we need any transparency in this body. Earlier this week, the Speaker of the House said to me that he was concerned about this institution. You want to know what? So am I. What's happening in this institution is outrageous. And that gavel and that chair is going to be here far longer than any one of us. This bill can travel on its own, through its own course, because this body has already waived the rules to allow that to happen. That already happened. But now, that wasn't enough. We're going to insert this bill in Ways and Means where it doesn't belong. The GOP members of the committee got up and walked out today because not only the way you treated them, but the way you treated Representative Detmer when you didn't allow him to do the same thing. It's outrageous, members. It's absolutely outrageous. And I expect that the rules of this House apply to everybody. And the transparency that we talked about when we passed the rules, where we talked about giving the public more opportunity to input, more opportunity to participate in the process, and more opportunity to know what's going on here. That's why they sent us here. They want us to work for them, not for our special interest union bosses. They asked us to work for them. That's why they sent us here. Let's at least give them an opportunity to participate in the process and to know what's going on. I'm glad the GOP members walked out of committee today. You deserved it. You shouldn't treat the minority this way, and you shouldn't treat the citizens of Minnesota this way. Thank you, Madam Chair.
The next bill on the calendar for the day is Senate File 671. The clerk will report the bill.
Senate File 671, number 1 on the calendar for today, the first engrossment, an act relating to public safety.
The member from Ramsey, Representative Paymar.
Thank you, Madam Speaker. I think I need to move the DEA 724 amendment.
There's an amendment at the desk. The clerk will report the amendment.
Paymar moving to amend Senate File 671, the first engrossment as follows. Delete everything after the enacting clause and insert the language of House File 724, the second engrossment. The amendment is coded DEA 724.
Madam Speaker, this just is inserting the House file into the Senate file.
Would you like a roll call?
Please. Have a vote on it.
Representative Paymar requests a roll call?
No, just to vote on it.
Oh, okay. Okay. He withdraws his request for a roll call. All those in favor of the Paymar amendment, please say aye. All those opposed, please say no. The motion prevails. The amendment is adopted.
Thank you, Madam Speaker. This is the Omnibus Public Safety Finance Bill, and I'll briefly walk through it before we take amendments. First in the bill is the Department of Corrections, which is the largest agency within our division. In this bill, we match the governor's proposal to increase the base budget by $38 million for the biennium, which will avoid any layoffs and maintain the basic agency operations at the DOC. What we also did in this bill is we increased by $3 million treatment for sex offenders. And the reason why we did this, and I'm glad the committee agreed to it, is that it's sort of shocking that we only treat 30% of the sex offenders in our DOC facilities, and 95% of those sex offenders are getting released, and they're going to your districts and my districts, and we want to make sure as much as possible that they're getting proper treatment. So that was the $3 million increase to provide more treatment beds. So the total corrections budget was $968 million, close to $970 million. The Department of Public Safety is the next next largest agency, and there's within that agencies, there's the fire marshal and alcohol and gaming enforcement. There were no changes made to that. We didn't use any of the fire safety account. This bill also, in the bill, we also funded the governor's recommendation for the school safety center, which is $1 million. It's $1 million per year over the biennium. And the school safety center was a center that we had several years ago that was provided by a federal grant that ran out, and then we stopped funding it. The School Safety Center is a law enforcement centered program that helps provide technical assistance and planning for schools to assess threats, hazards, and vulnerabilities, and conducts exercises. And in light of the school shootings, the School Safety Center will provide, I think, needed technical assistance to the schools throughout the state of Minnesota. In the Bureau of Criminal Apprehension, we appropriated money. This was a governor's recommendation for equipment and additional staff for a repair and replacement of lab equipment. We add 2 additional drug chemists and 2 additional toxicologists. Right now we have a significant problem with turnaround time, and that's especially acute with the closure of the St. Paul crime lab. We also concurred with the governor's recommendation to replace the criminal history system, which is over 20 years old. And the criminal history system contains information on persons arrested for felonies and gross misdemeanors and some misdemeanor offenses. And this information is critical for the criminal justice system agencies. We agreed with the governor and to replace the state's crime report system, which is used to report crime statistics to the FBI and is required by every state. That system is so old right now that it cannot be integrated with other systems, and this was both of these system replacements were key priorities of the Department of Public Safety. We also agreed with the governor's recommendation on live scan machines, which takes and transmits fingerprints electronically. And in the Office of Justice Programs, we appropriate an additional $3 million. This was also a governor's recommendation to crime victim programs. So this goes to your battered women's programs, sexual assault programs, and general crime victim programs. They had been cut over the years. This restores a lot of the funding. We also increased a bit over the base for youth intervention grants. This was a Simon bill. We weren't able to fulfill the budget amount requested by Representative Simon and the youth intervention programs, but we did give them a slight increase. There's also a one-time appropriation to a community reentry program in Duluth, which is a Simonson bill. In the Office of Emergency Communications, we added $1 million per year from the 911 Special Revenue Fund for maintenance of the armor system. And in the Department of Human Rights, We appropriated additional $129,000. This was a governor's recommendation to hire 2 additional enforcement officers dedicated to contract compliance. The private detective boards got a 1% base adjustment included in the omnibus bill. The post board, there were no changes. There are a couple of policy provisions that came from the governor, and one clarified that funds from the trunk highway fund can be used for the BCA, and another was to provide payment for from the federal government as well as other states to house offenders in the Department of Corrections, making it simpler. There are 2 policy bills that we also included in the omnibus bill because they had a price tag to them. One of them was a Kiefer bill that enhances penalties for certain repeat criminal sexual contact offenders. The other was a Simonson bill that was actually brought to us by the Sentencing Guidelines Commission because there was a provision that was inadvertently repealed when the legislature created life sentences for some sex offenders. So those are the only 2 policy bills at this point anyway. The public safety target was $49.5 million above the base. And with that, Madam Speaker, I have 2 amendments, and then we can take others.
There's an amendment at the desk. The clerk will report the A16 amendment.
Paymar moving to amend Senate File 671, the first engrossment as amended as follows. The amendment is coded A16.
Representative Paymar.
Madam Speaker, this amendment reinstates the stricken language in the policy provision on trunk highway funds being used to pay tort claims. This language is actually in the transportation policy or finance bill, one of the 2. So it doesn't need to be in this bill, and it's being removed. I'd ask for your support.
The member from Scott, Representative Beard.
Thank you, Madam Speaker. Representative Paymar, to be clear, and I should look at the amendment here in my pile, was that the appropriation you're removing or the language that makes it actually legal for us to do that?
Representative Paymar.
Madam Speaker, Representative Beard, the language allowing the department to do that.
Representative Beard.
Thank you, Madam Chair. Representative Paymar, I'm not sure that the Transportation Finance Bill, and I'm looking at Chair Hornstein, we have the appropriation, but I don't think we have the language. I recall from the discussion in Ways and Means, and pardon us, Madam Speaker, while we have this discussion, that for several years we've been doing this sort of unlegally, if I might put it that way, and that the language you had actually cleaned that up. So if your amendment actually strikes that language, I would argue that perhaps we need to leave that in there.
Representative Paymar.
Madam Speaker, I understood that the language was in the transportation bill. If it's not, we can leave it in here for now, but I don't think it should. I don't think it belongs here.
Representative Beard.
Madam Chair, after a sidebar with the Chair of the Transportation Finance, I think if it's not in our bill, perhaps we'll have an amendment when it comes to the floor, and we'll put it in our bill, and then everything will be Hoyle.
Representative Paymar.
Representative Beard, that would be a fine idea.
Seeing no further discussion to the amendment, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk.
Okay, yeah, I appreciate it. If something comes up, yeah.
There's an amendment at the desk. The clerk will report the amendment.
Mullery and others moving to amend Senate File 671 as amended as follows. The amendment is coded A17.
Representative Mullery. Representative Paymar's next amendment is an amendment to your amendment.
Madam Speaker,
Representative Paymar.
I think you have that wrong. My amendment should be the A9 amendment, which should come, and then the Mullery amendment should follow. I'm okay if you want to take the Mullery amendments now, but
Will temporarily lay over the Mullery amendment. Paymar offers the following amendment.
Paymar moving to amend Senate File 671, the first engrossment as follows. The amendment is coded A9.
Representative Paymar.
Madam Speaker and members, this amendment deals with sexually exploited youth, and this is part of what's called the safe harbor provisions that this legislature has been dealing with the last few years, and we should be very proud that bipartisanly over the last few years that we have really put an emphasis on trying to deal with the problem of trafficked children in our state. And the request was quite significant. I think it was $10, maybe $13 million. We couldn't do that, but Representative Allen and Representative Clark had provisions that are actually in Representative Huntley's. Well, one is in Representative Clark's bill, one is in Representative Huntley's bill, and just in a nutshell, there's three components to this. One has to do with expanding housing for trafficked children, sexually trafficked children throughout the state, so that if you have a battered women's shelter in your district, eventually we will be expanding beds so that law enforcement can bring sexually trafficked or children there to make sure that they get the proper services that they need. What we're doing here, and the model project that we're funding is in Ramsey County, which we are requesting $375,000 each year for a grant, because Ramsey County has really gotten the ball rolling with the grant from the Women's Foundation, and they are developing model protocols for law enforcement training. And so this is really the next step. So we have the housing piece that we're beginning, the advocacy piece. The piece that's missing is training law enforcement officers and prosecutors on how you deal with trafficked children. And I would like to, if I could, ask Representative Allen to yield for one moment, if she would maybe just explain a little bit, since it's her bill, about the Safe Harbor program, and then I'll explain a little bit more about the appropriation.
She will yield. Representative Allen.
Thank you, Madam Speaker. Representative Paymar. First, I want to say thank you to everyone that's worked on this bill. And I had the honor of carrying this bill, and many stakeholders worked on this bill many years. And in 2011, it was historical what was done in the 2011 legislature to enact the Safe Harbor legislation. Under the Federal Trafficking Victims Protection Act, a person under the age of 18 who has been induced to perform a commercial sex act is a victim of a severe form of trafficking. Yet many state prostitution laws allow for the prosecution of juveniles who are trafficked, despite the exploitation these children experience from pimps and sexual traffickers. The Minnesota Safe Harbor for Sexually Exploited Youth law, passed in July of 2011, addresses the key components of the End Child Prostitution, Child Pornography, and Trafficking of Children for Sexual Purposes model Safe Harbor legislation. The 2011 Safe Harbor law resolved the conflict in Minnesota law that defined a sexually exploited youth as both a victim and a delinquent. This conflict sent mixed messages about how our society and the legal system should be treating child victims. The 2011 Safe Harbor law amended our child protection laws to treat sexually exploited youth as children in need of protective services. The 2011 law also mandated the development of a statewide model, including recommendations for funding services for exploited youth. This legislative mandate also required that there be no fiscal burden to the state to develop the model. And to that end, the Women's Foundation of Minnesota agreed to fund the development of that model. And so that fund enabled the Department of Public Safety, so that would be the Commissioners of Public Safety and Health and Human Services, to work with other governmental and non-governmental organizations to create the No Wrong Door model. And that is House File 485. And this amendment seeks to fund that, a portion of that. And this amendment will fund training for law enforcement officers. They will be trained on best practices and victim-centered investigations for use in, it will be used on arresting, I'm sorry, glasses here. On arresting traffickers, and most importantly, they will be trained to identify exploited youth who typically do not come forward and self-identify as victims. The expansion of developed police protocols will enhance law enforcement's ability to hold traffickers and commercial sexual abusers accountable while ensuring these children are seen as crime victims. Thank you.
Representative Paymar.
So Madam Speaker, that sort of explains where we're at this point. Again, it's not as much as we would like to provide, but this gets us off on the right track. And let me just tell you how the money is going to be used. It will there'll be a grant to the Ramsey County Attorney's Office to develop this toolkit or curriculum for law enforcement and prosecutors and other practitioners who intervene, including child protection workers. This program is going to be a model for the country. I'm absolutely convinced of it. Once the toolkit curriculum is designed and developed, the Ramsey County Attorney's Office will provide 8 regional trainings around the state of Minnesota, and we have an appropriation here of $100,000 in fiscal year 14 to the post board, so that law enforcement agencies can send police officers to these trainings and get the up-to-date best practices intervention on trafficking. And so, and how we paid for this is through the some of the savings from MA that the Department of Corrections will realize with the Affordable Care Act and outpatient treatment offenders who have to use our hospitals, and some of those savings then will be used to fund this program. The rest of the savings are going to remain in the Department of Corrections budget. And I believe Representative Cornish, who's also been helpful on this bill in the past, would like to say something.
The member from Blue Earth, Representative Cornish.
Thank you, Madam Speaker. And Madam Speaker and members, yes, this is a good idea, and it's not spending new money. It's a transfer from within, from a savings, and overall good project, and I encourage a green vote. Thank you.
Seeing no further discussion, all those in favor of the amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Mullery and others moving to amend Senate File 671 as amended as follows. The amendment is coded A17.
The member from Hennepin, Representative Mullery.
Thank you, Madam Speaker and members. Basically what this is to help straighten out kids when they first get into some problems. And right now the court can stay the adjudication after the youth admits that they did the crime. Many youth need treatment, and what is needed is to see if we can straighten out the kid rather than just lock them up and then have no treatment for them, which usually ends up they're committing more crimes.
Which one?
So the court can do this exactly already on its own for 180 days, but according to all of the people involved, that's not long enough for treatment. Or having a lot of probation officers say they need a stick over the kid to keep them conscious of behaving correctly. And we also need to provide specific types of services directed to different youth, because each youth is different and different negative influences on them. So we've been working on this for a couple years. This is the biggest issue for the Juvenile Justice Reform Coalition, and especially the probation officers. And the probation officers, members, are the ones that we count on to make sure that these kids at the end of probation are ready for society and not going to commit crime again. So basically that's what this is. As I said, everybody's okay with this now, from the county attorneys to the Juvenile Justice Reform Coalition, and it's the top issue for probation officers. And just a quote from the probation officers, MACAC represents about 80% of the probation officers in Minnesota, and they said in their policy position, lengthened stays of adjudication will enhance public safety by increasing the amount of supervision to ensure responsivity to community-based education and treatment, and that it is to allow this is to allow greater assessment and treatment of juveniles before an adjudication is made. So with that, members, this is good for everyone. The juveniles who are just starting to stray, this doesn't apply to your serious juveniles, and it's also good for society because it gives juveniles something to treat their problems and to keep them under supervision for a while till they get straightened out and make sure that they're not committing any more crimes.
There's an amendment to the amendment. The clerk will report the amendment.
Drazkowski moving to amend the Mullery amendment as follows. The amendment is coded A19.
Representative Drazkowski.
Thank you, Madam Speaker. Madam Speaker and members, this amendment changes the amount of time. There is a continuance offered in Representative Mullery's amendment to allow 3 successive periods of 180 days each, which, members, that multiplies the amount of time in current law by 7. It goes from 90 days to 180 days, and then also adds the ability for another 3 sets of 180 days. Members, this amendment would increase it by 3 times instead of 7, which accomplishes some of what I think Representative Mullery wants to do, but doesn't increase all those additional costs to the court and continue to provide that shroud of public information over the case for that amount of time. So I'd appreciate your support for the amendment and ask for a roll call, Madam Speaker.
Representative Drazkowski requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Representative Mullery.
Thank you, Madam Speaker. And Representative Drazkowski seem to have a little problem with adding up times. Right now, there's 180 days that can occur on the court's own decision. There is no extension of that. Mine would extend it 3 times for that amount, but only with the prosecutor's approval. And it gives the prosecutor also the right, in case a judge extends it without their approval, the prosecutor is given the right to go to the appellate court and have that set aside. This is something that was really worked out for a long time, and to break part of this deal would be outrageous, Representative Drazkowski. Everybody has agreed to this now. People got different parts of this. Not one part of this amendment is what anyone wanted, and to break a deal that's been worked out by the experts based on somebody who hasn't been very involved with this, to say the least, in the past, is totally in opposition to what we should be doing. The MACAC, which, as I said, represents 80% of the probation officers in this state, their board unanimously adopted the 2-year provision. MACPO leaders at one time asked for 1 year, but then they now support the 2 years. And in talking to their former head, he said most MACPO people, which represents a lot of the other 20%, most of them, he said, actually want more than 2 years. A lot of the probation officers in the metro area say they need 2 years or more. This was agreed to by all of the parties, and if you start breaking things down, then all of the agreements are out, and it's totally unfair to the others who gave on things that they didn't want to give in. We need this because a lot of youth are not treatable within 1 year. Yes, the majority are, but let's say 60 or 70% are treatable within 1 year. That leaves 30 to 40% of the youth that need more treatment. They need to be straightened out, and what you're doing is endangering society because you're cutting off the treatment. So if you want to continue on this, then you're endangering society, Representative Driscollowski.
Seeing no further discussion, the clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 58 ayes and 71 nays, the amendment to the amendment is not adopted. To the Mullery amendment. Seeing no, Representative Albright.
Rise for a point of order.
Representative Albright rises to a point of order. State your point of order.
Madam Speaker, under Rules 3.21 for motions and propositions, I don't find that this amendment is germane to the topic at hand.
Advice, Representative Albright.
Thank you, Madam Speaker. Advice. We just heard the bill just before us. I find that this should have been heard in public safety, not or in judiciary, not in public safety. The courts have the opportunity to grant continuances of adjudication. This should have been found germane to the bill we just passed.
Representative Scott, for what purpose do you rise?
Advice, Madam Speaker?
State your advice.
As Representative Albright pointed out, this bill or this amendment for Representative Mullery's was heard in Judiciary, and that's exactly where that belongs. This really doesn't have anything to do with public safety, so I would request that you find in favor of the point of order.
Representative Mullery, for what purpose do you rise?
Madam Speaker, advice to the Speaker.
State your advice.
Thank you, Madam Speaker. Basically, this bill or this amendment is germane to both the judiciary and public safety bills. There's not much question about that. This bill deals with what happens when the court does an action, which is they turn it over to corrections and probation, which is all in the Public Safety Committee. So everything that is happening under this amendment is in the Public Safety's jurisdiction. We have funded those corrections, probation, youth intervention. We funded those in the Public Safety bill. They've always been in Public Safety. There is no question that this is clearly within both jurisdictions of each committee.
To the point of order raised by Representative Albright, and having heard and considered the advice of Representative Albright, Representative Scott, and Representative Mullery, I find the Albright point of order well taken. There's another amendment at the desk.
Madam Speaker,
Representative Mullery.
did you rule the point was well taken?
I did, Representative Mullery.
Madam Speaker, I'll appeal the ruling of the chair then.
Representative Mullery appeals the ruling of the chair.
Madam Speaker. Madam Speaker.
Representative McDonald.
I was standing, Madam Speaker. Nobody was in my way, Madam Speaker.
I'm sorry, Representative McDonald. I did look around and I did eventually see you.
I won't take it personal this time. Roll call, please.
Representative McDonald requests a roll call. Seeing 15 hands, there will be a roll call. Representative Mullery.
Madam Speaker, as I said, probation is funded in this bill. Corrections is funded in this bill. They are the ones that handle the supervision of what's going on in this. The person is under their supervision during this continuance. Therefore, it is clearly within the jurisdiction and it's within the germaneness. It's clearly germane to this bill, including youth intervention also is funded.
Representative McDonald.
Madam Speaker, I withdraw the roll call.
Representative McDonald withdraws the roll call. Is there any further discussion to the appeal?
Madam Speaker.
Representative Kelly.
Advice, Madam Speaker. I want to just rise and support your original decision. I think Representative Mullery, what you're trying to do is not a bad thing, but the problem is that we did not hear this in public safety. You did run it through Judiciary. If it was germane to public safety, I would assume that we would have heard that. If there's one thing I've learned about serving on the Public Safety Committee over 6 years is regardless of whether Chair Paymar is running or Chair Cornish, we have a very good, well-run committee, and we vet everything that we're supposed to. So I would urge a support of your ruling, Madam Chair. Thank you.
Representative Woodard.
Thank you, Madam Speaker, and I'm in the delightful position of giving advice to support your ruling. I think you're absolutely correct here. I am a former co-author of this bill. There's been some changes to it that I still have some questions about, but undoubtedly it was a judiciary responsibility here, and certainly under the purview of the Judiciary Committee and the Judiciary bill we just heard not moments ago. So I would urge the body to support your ruling.
The question before the body is, shall the decision of the Speaker stand as the judgment of the House? A yes or a green vote? Representative Mullery.
Madam Speaker, I'll withdraw.
Representative Mullery withdraws his appeal of the ruling of the Speaker. There's an amendment at the desk. The clerk will report the amendment.
Mullery and others moving to amend Senate File 671 as amended as follows. The amendment is coded A18.
Representative Mullery. To the A18 amendment.
Madam Speaker, this is an effort to try to get at the disjointed ways that we treat youth that get into trouble. Right now, we had testimony in our committee that many of the systems and the agencies don't work together on youth when they start to get in trouble. And so what this would do would merely require the different agencies, etc., to discuss issues with the National Alliance on Mental Illness. National Alliance on Mental Illness, when we couldn't find other funding for that, they felt this was so important that they would fund the study and fund the report. And what it is intended to do is get at things like the fact that right now you have totally separate children need a protection system from the delinquency system, from the mental health system, from the educational system, and many others that work together or should be working together but aren't working together. And NAMI, National Alliance on Mental Illness, is willing to fund a study on how these should be working together. And so that's all this is.
Discussion. Seeing no discussion to the amendment, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Cornish moving to amend the Senate File 671, the first engrossment as amended as follows. The amendment is coded A4.
Representative Cornish.
Madam Speaker and members, the A4 amendment, what this is taking the funding from two of the FTEs that were added to the Human Rights Commission in this bill and sending the funding to the BCA. And the purpose of this is to Commissioner Lindsay's report to us during committee hearings was actually that the performance of this department has improved and that the time it took to investigate some of these complaints has actually been shortened. So I see really more need for this money in Bureau of Criminal Apprehension for apprehension of criminals rather than treating some of our business as there's a criminal investigation going. So I would like to have the support of the amendment to transfer the money to BCA, and appreciate your support, and let them use it as they wish for solving crimes and crime lab technicians and the new equipment that they need, and to shorten the time that it would take to get back the evidence to our law enforcement departments. Thank you. And this actually was a bill that passed the House before and went to conference and came back without it. So.
Representative Paymar.
Madam Speaker, I would respectfully ask the body to reject the Cornish amendment. This was a governor's recommendation. The Department of Human Rights has been significantly understaffed for many years, and although they've been able to close cases much more quickly and a lot of discrimination cases brought to the department needs this to shorten the compliance time or the monitoring of compliance time. This will actually help businesses, and that's why they need the additional staff, and I respectfully ask that you defeat the Cornish amendment.
Representative Cornish.
Madam Speaker, I just ask for a roll call, please.
Representative Cornish requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Seeing no further discussion to the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Johnson B. moving to amend House File 671, the first engrossment as amended as follows. The amendment is coded A6. B. Johnson B.
Madam Speaker.
Representative Cornish.
Madam Speaker, could we lay that one over temporarily?
We can. Representative Johnson temporarily withdraws his amendment. There's an amendment at the desk. The clerk will report the amendment.
Newberger moving to amend House File 671 as amended as follows. The amendment is coded A5.
The member from Sherburne, Representative Newberger.
Thank you, Madam Speaker. I rise to offer this amendment today. If we look through the language of the bill here, we have some automatic increases that were not recommended in the governor's budget. They were part of his recommendations. This is an automatic increase that was not requested by the departments either. It's a small decrease that I'm asking for here from the private detective board. It's only $3,000. And then another small decrease from the Human Rights Department of $76,000. Again, these were not recommended, these were not requested, these were automatically grafted in. Madam Speaker, I think it's a good opportunity for everyone here to demonstrate some fiscal responsibility, to vote against some increases that weren't asked for or recommended. So I'd urge a green vote on this amendment. Thank you.
Representative Paymar.
Madam Speaker, again, I would respectfully ask the body to vote against the Newberger amendment. I understand that we need to be fiscally responsible, but keep in mind some of these departments have not had any increases in many, many years, back to, I think, the Private Detectives Board, which is primarily a fee-based board. I don't think that they've had a compensation increase since 2008. The Human Rights Department has been subjected to cuts of 3% in 2010 and 8% in 2012. And I think that I would just ask the body to please reject the Newberger amendment.
Representative Newberger.
Thank you, Madam Speaker. I would agree with the good Representative Paymar's advice here. However, these increases were not recommended, nor were they requested. I would ask for a roll call on this, and thank you very much.
Representative Newberger requests a roll call. Seeing 15 hands, there will be a roll call. Seeing no further discussion to the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 69 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk.
Uglum moving to amend Senate File 671. The first engrossment as amended as follows. The amendment is coded A7.
Representative Uglum.
Thank you, Madam Chair. Members, Representative Paymar, I think we have an amendment here that is definitely worth talking about and definitely worth considering. This amendment eliminates the Department of Human Rights 2 additional compliant enforcement officers and transfers the money, $129K, to the Homeland Security and Emergency Management Division to supplement the School Safety Center. That's the School Safety Center. I mean, we've all read the headlines about Sandy Hook. Obviously, we know what's going on in Boston at this very minute. This is some money that needs to go to protect our schools. It is a matter of priorities. Human Rights Department is very important. There's no question about that. But I can tell you, I, for one, would hate to go to bed some night and say, I didn't look at this and do everything I possibly could to protect our schools and have another incident happen. We've had these incidents happen in Minnesota, and we don't want them to happen again. It's a small amount of money. It may be just a temporary thing until the next budget comes around, but this is an important amendment. It's an important amendment for our children. It's an important amendment for our state. It's not your usual amendment, and it's definitely bipartisan. I would urge a green vote for this amendment, and I would ask for a roll call.
Representative Uglum requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Representative Paymar.
Madam Speaker, Representative Uglum, thank you for the amendment and the bringing the proposal forward. I guess I wish that we would have had more discussion on the School Safety Center when the department actually came before our committee. I think that would have been a good time to ask whether we had sufficient funding or not, because maybe we would have considered it. I think everyone on our committee shares the concern about the safety of our schools. That's why I believe there's money in the K-12 budget also for school safety in Representative Dabney's bill, and there's a levy authority for officers in our schools. So I think we're trying to address this. Had the department asked for more money, I think we would have considered it in committee. And this is the governor's recommendation. This is what the department thinks that they need. If they want to come back next year and say after measuring the success or assessing their success, then we could certainly appropriate more money. But to just give them more money when they're not requesting it doesn't seem like the wisest thing to do. And I also again think that would be unfortunate to cut these two needed positions at the Department of Human Rights. So I would respectfully ask that we reject the amendment.
Seeing no further discussion to the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. There being 59 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Johnson B. moving to amend Senate File 671 as amended as follows. The amendment is coded A6.
The member from Isanti, Representative Johnson.
Madam Speaker, I'll withdraw my amendment.
Representative Johnson withdraws his amendment. There's an amendment at the desk. The clerk will report the amendment.
Lomer moving to amend House File 671 as amended as follows. The amendment is coded A2.
The member from Washington, Representative Lomer.
Thank you, Madam Speaker. Members, this A2 amendment transfers $1 million out of the $70 million out of the Office of Justice program. It's biennial appropriation to the Homeland Security and Emergency Management Division to supplement the School Safety Center. So we're going back to that very, very important program. So this would really be a good addition, Representative Paymar, I think, to what you've already appropriated to them, and I know that this is something that the governor really, really likes and supports. So, we believe that the safety of students and teachers and staff in our schools is one of the most important things that the government can do. We need to do all that we can to enhance school safety. The Division of Homeland Security and Emergency Management in the Department of Public Safety is the best suited to coordinate those efforts. And this will essentially be seed capital to make our schools better and safer. So this appropriation is really barely enough to reestablish the School Safety Center. And again, we know that this is good work that the Department of Public Safety can do. So I encourage a green vote, and I would ask for a roll call.
Representative Lomer requests a roll call. Seeing 15 hands, there will be a roll call. Representative Paymar.
Madam Speaker, Representative Lomer again, I respectfully would ask that the body reject the A2 amendment. I think I hope I've made the case that this is what the Department of Public Safety has requested. This is what the governor has requested. This is what the School Safety Center needs to resurrect itself and provide the kind of technical assistance to our schools to ensure that our students are safe. I would further add, members, that the Office of Justice Programs has been cut over the years. So if you go back to your districts and your battered women's shelter or your sexual assault program or your crime victim program says, why did we get a cut? Well, if you vote for this amendment, you'll have to explain that. If you have a gang or a drug strike task force in your district, which many of you do, that does very important work, and they get cut, you'll have to explain that. If you have a youth intervention program that works with troubled kids to keep out of the juvenile and adult criminal justice systems, and if those programs get cut, you'll have to explain that also. So I wished again, Representative Lomer, Representative Uglum, and others, that we would have had this discussion about the School Safety Center and we could have maybe adjusted our budget. I, quite frankly, asked members of the other side for your input, and as you know, I've tried to include what bills. I think I heard almost all of your bills, and I would have entertained this, but you did not respond to that request. So, Representative Lomer, I appreciate the effort, but again, I would ask the body to reject the amendment.
Seeing no further discussion to the amendment, the clerk will take the roll on the amendment. The clerk will close the roll. There being 59 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Cornish moving to amend House Law 671 as amended as follows. The amendment is coded A3.
Representative Cornish.
Thank you, Madam Speaker. Representative Paymar, I'm going to give you one more chance. First I have to apologize. I screwed up here a little while ago in my other presentation. I said that was a bill that had passed the House floor. This actually is the bill that passed the House floor last biennium. Members, let me hit send here, and there we go. Momentarily, you will have the amendment on each one of your computers. And what this is actually is right now there's 2 postings of sex offenders in our state that are supposed to provide transparency to the public and that we can look these folks up. And one of them is at the BCA. The BCA lists the individuals that fit the definition of a predatory offender and that have not complied with the requirements related to registration for at least 30 days. So that's the BCA list. You can look that up on the website. You'll see it on your computers now. Hopefully you won't recognize anybody. The DOC, the Department of Corrections, lists all the level 3 predatory offenders who are in your community. So you can put in your zip code or your city and you can find out where the level 3 predatory offenders live. The problem is there's 2 different websites. And what I proposed in the House File 955 last biennium that passed the House was that we combine these and we take those, the FTEs and the program from DOC and put it with BCA. The interesting thing is that division of BCA came and testified in front of us, said they were willing to accept it and they could accomplish it. So what this does is transfer the money from that program, from the DOC to the BCA, puts it all under the BCA. They said they can accomplish it. And whether the corrections really approves of this or not, ask yourself this question. In the last 10 years, have you ever heard of a state agency that's willing to carve off part of themselves and give it to somebody else and chisel off a piece of their kingdom? The answer is no. So whether they really want to or not, it shouldn't really be the question. It's what's good for the public and transparency. So it makes sense. The money is there. It's a transfer. The public only has to go to one site to look up these individuals, and it's good for public safety. And Representative Paymar, you should really accept this. Prove that it's a good bill. Thank you very much. I appreciate it if you would ask for a roll call and a green vote.
Representative Cornish requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Representative Paymar.
Madam Speaker, Representative Cornish, appreciate the effort and your concern about trying to make this, the website more efficient to the public. However, I would just add that the Department of Corrections, as you know, does not agree with what you're doing. This is a letter from the Commissioner. He said, and I have copies of it if the body would like to see it, but he said nothing is broken. The Department of Corrections has operated an easily accessible site very well since 2000. The Commissioner also says that the bill, if the amendment, if we add this, will decrease efficiency. And by introducing the BCA into the community notification process, which already includes the DOC, local law enforcement, prison case managers, corrections agents, jailers, and others, it will increase the bureaucracy of the current system. And he also adds that there are costs to the BCA. So I guess if you want to criticize the Department of Corrections and their bureaucracy, you can. But if you go to the other side of the bureaucracy, which is the Department of Public Safety, you also see that they also oppose the amendment and that they don't want to undermine the Department of Corrections. This is not something that they've asked for, and it's not something that they're advocating for. So you have both departments objecting to your amendment. The final thing I would say, Representative Cornish, with all due respect, is that last year when you tried this and you got it successfully passed through this body, I don't believe that you paid for this transfer. Maybe you did, but unfortunately where you're taking the money now is you're taking it from probation officers who provide the intensive supervision to sex offenders. That's where the money would come from. Probation officers who provide intensive supervision to sex offenders. So while maybe there's a good reason to do this, I don't know, but that's certainly not where you'd want to take the money from. And when both departments are opposed to it, I think we should also. So Representative Cornish, I'd ask you to either withdraw your amendment, or members, or vote it down, members. I just think this is not the proper amendment.
Representative Cornish.
Well, Madam Speaker, Representative Paymar, you couldn't have given a more off-base description. This has absolutely nothing to do with sex offenders or probation officers. That never came up in any of the hours of testimony we had 2 years ago. And I will rise to criticize the bureaucracy of the Department of Corrections. The only reason that the BCA has backed off of this is that the Commissioner of Corrections has beat the Commissioner of the BCA over the head with a stick and said, hey, don't accept this. It's awful curious that 2 years ago they were willing and anxious to take it, said they could do it. Now all of a sudden they object. That's because the Department of Corrections has been on their case not to take it. And that's what happens with our state agencies. You'll never find a state agency that's going to give of themselves to somebody else. This has nothing to do with sex offenders. It's a good policy. I'd appreciate a green vote. Thank you.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There being no further amendments at the desk, the clerk will give the bill its third reading.
Third reading, House File 671, as amended.
Third reading. Discussion. The member from Mille Lacs, Representative Erickson.
Thank you, Madam Speaker. Would the author of the bill please respond?
He will yield. Representative Erickson.
Thank you, Madam Chair. Representative Paymar, I know that the Safe School Center will be a part of this legislation if it goes forth. And in studying what other states have done, even though you have quite a good amount for the first 2 years of the resuming of the Safe School Center, I find that in studying other states, this is going to be such a huge cost to school districts because they're going to have to make so many adjustments if they're actually going to provide the safe environment that seems to go along with safe school centers. I don't know if you can answer this question about what do you have in mind, because I heard you say earlier you're not sure. But, you know, if this part of our bureaucracy is allowed to look at what other states have in mind or what other safety centers have in mind and have imposed on their school districts, it's going to mean that sites might have to be changed, that roofs have to be redesigned, that topography has to be considered, that there are internal things within the design of a school that have to be considered. And I just fear that we're going down a road of extreme cost to our districts if the safety center gets carried away with their command, I guess, that they may think they've received through this legislation. So would you comment on what you think might be ahead? Because we have dollars in the K-12 bill, and you know, I'm just concerned that this could lead to something way beyond what we fathom today when we're debating this provision.
Representative Paymar.
Madam Speaker, Representative Erickson, good point, good question, and I think you raise an important issue that we should be evaluating this program. I think members, you know, on our committee had some serious questions about the center. We wanted, the center is not new. It functioned before under a federal grant. This is quite different, I think, than the proposal in the K-12 bill that dealt with bullying and not that that's not relevant to this discussion, but this is a very law enforcement based technical assistance center. So the way I understand it, and believe me, I'm not an expert on it, and I think we need to evaluate how it goes forward. But the way I understand it is that they would contract with schools. They wouldn't contract. They would provide advice to schools. This is an ongoing appropriation, so they wouldn't be able to do, obviously, all the schools in the state of Minnesota. And they would help them sort of assess how they currently handle their preparedness for a potential shooter in the school or any other threats. Most schools already have policies and protocols for bomb threats, et cetera, et cetera. So I think that what they're trying to provide is the technical assistance for school districts to understand where they might be vulnerable. Now, the question is, you know, does that mean that they have to have capital improvements in the school to close off certain areas? You know, I don't really know. I think that that advice might be provided to a school. Whether they actually follow through on it, of course, will depend on the school district and how much resources that they have. But I think that the training and technical assistance based on their skill level as law enforcement officers is going to be important. I think we should give it a chance in the heightened climate where we've had these school shootings. You know, we can't 100% guarantee the safety, but I think we should give the center a chance, and that's why the committee agreed with the funding.
Representative Erickson.
Thank you, Madam Speaker, and thank you, Representative Paymar, for those comments. I just wanted to make sure we had on record, members and Madam Speaker, that we do not want a school safety center that's going to start dictating to our school districts some major capital improvements. If they provide training, that's exactly what we want. If they give advice in a technical way, as Chairman Paymar has pointed out, that's what we want. But it so often is true that once we recreate something, and we had this once under federal funding, but once we create it now through state funding, we may have demands made on our school districts that are going to be costly to the taxpayers, to the school district, and I presume that for future siting of school buildings that there's going to be a lot of demand coming through engineering and architecture to ensure a safe structure, and that of course will mean more cost. The most important thing is that we have safe environments for our children, but at the same time we have to use common sense. But thank you, Chair Paymar, for letting me get this on the record and for your response.
The member from Isanti, Representative Johnson.
Madam Speaker, Representative Paymar, I want to thank you for your work on this bill. Overall, it's not a bad bill. It could have used a little bit of tweaking here and there, in my opinion. Public safety is one of the main things that government is supposed to do. As the incident that occurred in Boston this past few days shows, and the work that law enforcement does, one officer actually put his life on the line, another one's in critical condition from last night going after these terrorist suspects. I wish we could have been able to put a little bit more funds to the BCA lab, because it was the laboratory in Boston and with the FBI that really helped in order to identify these individuals that did this bombing. The equipment at our current lab is getting old. In testimony to this during our committee, they indicated that some of their equipment is more than 20 years old, and when it breaks, they cannot get parts for it. It's something that we do need to look at, and there's some funding that I think in this bill that could have came from other places to assist in getting the equipment done to help BCA and the lab get the information to the officers to put these criminals behind bars. But as I said, Mr. Representative Paymar, overall it's a good bill. I wish it could have had a little bit more tweaking.
The member from Washington, Representative Kiefer.
Thank you, Madam Speaker. I wanted to thank Chair Paymar for giving fair hearings throughout this session. We had some pretty controversial bills on the floor, and I really want to thank you for your integrity. I also want to thank you for helping get House File 142 included in the bill. It's been 3 years in the works, probably longer than that before I took it on. So appreciate that, and I will be supporting your bill. Thank you.
The member from Hennepin, Representative Uglum.
Thank you, Madam Chair. I, too, would like to thank Representative Paymar. I think he ran a very good committee. Some difficult times, no question about it. This is a pretty good bill. I think it could be a little bit better, but public safety is so important in this day and age, and it's so important that we do a good job and support our BCA and everything else that's in this bill. So I will be supporting this bill, too, and I'm happy to do so.
The member from Blue Earth, Representative Cornish.
Madam Speaker and members, Representative Paymar, I'd like to thank you for our interesting exchanges this year and our fun in the committee. Some of them were a little tense, but I think we were respectful of each other and nobody even got injured. And I would like to also thank Laura Holsey and Kate Weeks. I think Rebecca Pierce is in the back. Thank you. And Jeffrey Diebel, John Walsh, the financial person, and for all of your help, and the DFL counterparts on the other side. I hope the time with us wasn't too difficult for you. And Representative Paymar, I think though we've had some difference of opinions, we did pretty good job. And I would differ with you in some of the areas we put this in. And our big fight will be on the tax bill this year. We'll see where you got this money here. So I'll reserve the right to argue that later. So thank you very much.
The member from Ramsey, Representative Paymar.
Thank you, Madam Speaker, and thank you all for the kind words to the Democrats and Republicans on this committee. It was a very respectful time debating I guess we didn't really debate so much the omnibus bill. I think we really came together on that. We had slight disagreement over the gun bill, but you know, those things can happen, Representative Cornish. But I really appreciate how respectful you were, even during those tense times and those tense hearings. And I would agree, Representative Johnson, I wished we could have done more with the labs. In fact, I wished we would have spent more money in the Department of Corrections. We didn't fund the DOC as much as I would like to, and whenever I think about one of those facilities and our correctional officers as well as the offenders there, I worry about the safety, and we have to keep in mind that public safety and these institutions and our law enforcement are core critical functions of government, and they should be adequately funded. And so, again, I'd like to thank all members of the committee and our staff for the great work that they've done in helping assemble the bill, and I appreciate your support.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 122 ayes and 7 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 819. The clerk will report the bill.
House File 819, number 3 on the calendar for the day, an act relating to Public Facilities Authority.
The member from St. Louis, Representative Murphy M.
Thank you, Madam Speaker. Members, House File 819 is a housekeeping bill for the Public Facilities Authority and the use of the Clean Water Fund that comes from the Legacy Fund in the Environment Bill. This bill has no money in it whatsoever. The bill that passed yesterday that dealt with clean water talked about the programs that some of the Public Facility Authority oversees or demands. The bill, the Legacy Bill, that will come up tomorrow has funding for the Public Facility Authority projects in it through the soil and water conservation districts and other grant-making agencies. This bill has no money in it, but it has some technical changes that expands what the Public Facility Authority can include in their criteria that will make it easier for your cities or counties or townships to apply for the grant monies. And so more of your cities could be eligible for the programs that the Public Facilities Authority offers to them. This is a housekeeping bill that changes the name of the grant-making programs to Point Source Implementation Grants. It is a bill that establishes the criteria, changes the criteria to make more cities and more applicants eligible to receive the funds that the PFA gives out for clean water and sewer.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 819.
Third reading. The member from Fillmore, Representative Davids.
Thank you, Madam Speaker. If the Representative Murphy would yield for a question.
She will. Representative Davids.
Thank you, Madam Speaker. Representative Murphy, does this bill have any money in it?
Representative Murphy.
Thank you, Representative Davids. This bill has no money in it.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 1168. The clerk will report the bill.
Senate File 1168, number 6 on the calendar for today, the first engrossment, an act relating to public safety.
The member from Hennepin, Representative Simon.
Thank you, Madam Speaker and members. This is a bill to up the penalties and create a new felony for those who make intentionally false and phony 911 calls. When we heard this in the Public Safety Committee, where it passed unanimously, that was before the hoax in New Prague, which of course shut down not only the school but the entire school district, as I understand it, for most of the day. This is a phenomenon, unfortunately, that's been spreading in other states, in California, in Louisiana, and now, unfortunately, in Minnesota. The specific focus of the bill is a new felony provision that says if someone knowingly and intentionally makes a false and phony 911 call, knowing that there's no emergency, and if there's a loss of life or serious bodily injury to someone involved, then there is a new felony involved here. This passed, as I said, unanimously in the Public Safety Committee. It passed the full Senate 62-0, and there is no money in this bill either. I urge your support, members. Thank you.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 1168.
Third reading. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 130 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 1195. The clerk will report the bill.
House File 1195, number 4 on the calendar for today, the first engrossment, an act relating to local government.
The member from Hennepin, Representative Nelson.
Thank you, Madam Speaker. And like all my bills, this is a nice non-controversial bill. Don't go laughing. Okay, anyway. But this is a non-controversial bill. What this bill does is gives Hennepin County the right to negotiate contracts with the construction labor unions. This is authorization has been given to given to Minneapolis, the Minneapolis School District, and the Municipal Building Commission. And the Municipal Building Commission's people, if you don't know what that is Minneapolis City Hall was built and is owned by both the City of Minneapolis and Hennepin County. And when they built this building, they created this building commission to take care of it. And currently, Hennepin County has 5 people that work for them in the Sentence to Service program, where they take people out and do work around the county. They did work at the Fort Snelling to weatherize those old buildings. And they have tradespeople that serve as foremen for these people to take these people out and do their work. And right now they've got an attachment to the Municipal Building Commission contract to put these people on. By giving them this authority that they can negotiate directly with the trade unions, they will be able to hire those people directly and not through the convoluted way they're doing it. And the building trades are in favor of it, the city's in favor of it, the county's in favor of it, and that's basically all the bill does. And I'll stand for any questions.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 1195.
Third reading. Seeing no discussion, the clerk will take the roll on the bill.
You think there's one?
The clerk will close the roll. There being 81 ayes and 49 nays, the bill is passed and its title agreed to. Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there are no objections, we will take action on those motions first. Hearing no objections, the motions prevail. Report from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Murphy E. moves for the Committee on Rules and Legislative Administration, pursuant to Rule 121 and 333, designates the following bills to be on the calendar for today for Tuesday, April 23rd, 2013. House File 630, Senate File 359, House File numbers 791, 1304, and 1124.
Announcements. Representative Sanders.
Thank you, Madam Speaker. Republican members, we will be caucusing briefly immediately after adjournment in room 317.
Announcements. Representative Murphy.
Thank you, Madam Speaker. I move that when the House adjourns today, it adjourns until...
Representative Murphy M.
Thank you, Madam Speaker. The DFL members of the State Government Committee could meet in our usual alcove.
Representative Murphy E.
Thank you, Madam Speaker and members. I move that when the House adjourns today, it adjourns until 10 a.m. Saturday, April 20th, 2013.
Representative Murphy moves that when the House adjourns today, it adjourn until 10 a.m. Saturday, April 20th, 2013. All those in favor, please say aye. Those opposed, please say no. The motion prevails. Representative Murphy.
I move that the House do now adjourn.
Representative Murphy moves that the House do now adjourn. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The motion prevails and the House stands adjourned until 10 o'clock a.m. Saturday, April 20th, 2013.